vision by the judiciary. Allow me to introduce the panelists. Before we start, I see many participants are joining. I will ask you if you have any questions. You can put it on the Q&A or the chat so that we can pick the same. We also want to have this very engaging, so we will seek to leave time at the end of the session to have an interactive session so that you can shoot your questions to the panelists before you. So without further much ado, allow me to introduce the eminent panelists that I have today. I've had the pleasure of serving with these eminent persons in the National Steering Committee on the implementation of AJS, and they are excellent and a very able lady and gentlemen. Allow me to start where I should. The good judge, Justice Francis Gikonyo, is a judge of the High Court, as you may know. He was admitted to the bar in 1991. He was a private practitioner up to 2008. He was in private practice, employed then by the Kenya Anti-Corruption Commission as the principal attorney in charge of civil litigation until 2009. He was then appointed. These were the 2010 constitutional judges. That is why they are very, very progressive. He was appointed as a judge of the High Court in 2012, a position that he currently still holds. He has been the presiding judge of various stations. Currently he's serving as a presiding judge of the Commercial and Tax Division, a very heavy and busy division at the Milimani High Court, and is doing exemplary work. He is a trainer of trainers at the asset recovery, corruption, and money laundering issues, election disputes resolution, and now a member of the NACI AJS, representing the High Court. So karibu sana, Justice, Mr. Justice, my Lord, Justice Gikonyo. That is our first panelist. Can wave to the people, they confirm it's you, Judge.
Yes, it's me. Thank you very much for that elaborate introduction.
Thank you, thank you. Our second panelist is a Luopin par excellence, Dr. Steve Akoth. He is a legal anthropologist with long-standing work on a dialectics of social justice. His PhD developed the concept of domesticated agency as an integral philosophy and practice in advancing everyday idea of justice. So he is at the center of what people-centered justice is all about. In the year 2010, he started focusing on alternative justice system together with Justice Professor Joel Ngugi, judge of the Court of Appeal in Nairobi. He has co-led their conceptualization, designed, and currently serves as the vice chair of the National Steering Committee on AJS. He's also served on the appointment of the Chief Justice Martha Koome as a member of the STAJ Steering Committee, that is the Social Transformation Through Access to Justice Steering Committee. So Dr. Steve is at the heart of implementation of the STAJ vision, and his deep understanding of a people-centered justice, of course, comes in handy. Daktari prefers to make his payments in dollars, so we are used to him flashing out the dollars, and it is now the norm rather than the usual. Daktari, karibu sana. Dr. Akoth can say hello to confirm we are together. Okay, I will move to my third. Yes, Daktari. Show your face and say hello. Okay, very well. You will see him shortly after. My third eminent panelist is an esteemed lady, Jemimah Teresa Collins Aluda Esquire Donge. JEMIMAH ALUDA is an advocate of the High Court of Kenya and a consultant of the rule of law and accountability. She holds a master's degree in law on Masters of Arts in Project Planning and Management from the University of Nairobi, LLB from Nairobi University, the University of Nairobi, and a postgraduate from Kenya School of Law. She has attended senior management courses on senior leadership development. She is currently a PhD student at the University of Nairobi. She served as a principal prosecution counsel at ODPP for 10 years. She brings a lot of knowledge and information from a prosecutorial point of view and what AJS initiatives can do to that end. She has consulted with UN and international organizations, including the UNODC, IDLO, UN Women, United Nations Office of the High Commission, 𝑀𝒓𝒂𝒅𝒊𝒕𝒊𝒐𝒏 Pamoja Trust, among very many others. Currently, she serves as a board member of Landesa Head of Secretariat at the National Steering Committee on the Implementation of Alternative Justice Systems, and represent the Law Society as in the task force member. She represented the LSK in the task force for the development of the National Administration Justice Bill, the NCAJ bill. So ladies and gentlemen, participants, welcome on board. As you have heard, this is quite a knowledgeable panel that we have in this area. And it is our pleasure to demystify the aspect of AJS and how it is practiced, how it is successful in the country. Allow me to begin where we should, the history, where did we come from, why AJS? So, Dr. Steve Akoth, you are the Vice Chair of the Steering Committee on AJS. Would you kindly just tell us what the committee is about and what is its mandate?
Thank you very much, Chair, and thank you for this invitation. Confirm you can hear me?
Yes, we can hear you.
Thank you. Allow me to really thank the Institute for inviting us and also to relay the goodwill from our Chair, Justice Professor Joel Ngugi, who commissioned us to join you today, and he brings his much well wishes to you and to this session. Now, back to your question. The question of where we began has many imperatives, but 4 of them are important. First, AJS is part of the larger vision of our Constitution for a plural society. But remember, our Constitution is not the first one to create a plural legal system. The colonial society, the colonial framework, the colonial governance was also characterized as a plural legal system. The only difference is that the colonial plural legal system was one where customary law and African practices were put at the low part of the rung. So AJS on the other side reframes this by creating a system of interaction that is not hierarchy-based. So that's the first thing. It is a constitutional call that this is what we have to do, and Article 159(2)(c) is very explicit about it. The second most important thing that emerged at the time is that when Justice Mutunga was in office, he did realize that methods such as mobile courts, such as ADR alone, such as paralegalism alone, were not enough, and that we needed a model of thinking about justice in a way that the justice seekers see themselves as part and parcel of the justice process. And this is a very important shift, because then you move away from the theory of justice where on the one side you have a provider and on the other side you have a seeker, towards a theory where the so-called provider and the seeker converge at some stage to produce the idea and the realization of justice. And that's a very important also imperative in the Constitution, the way we see it. And that second imperative that led us in that direction. The third one was really because people choose. People choose to go to forums where they think they'll get their idea, their meaning, their outcome of justice. And many Kenyans, we realized, were choosing forums outside the state-based courts. And therefore, it became imperative for the court to follow them where they were going to be able to think through how to work with them to get that very quest of justice. And the final one, the fourth one, is that we didn't realize that the justice gap in the country, that is the number of people whose justice needs were met, were increasing even when more courts were being constructed, even when more advocates were being admitted to the bar, even when we were appointing more judges and magistrates. And therefore, our question comes to the table on what can we do to ensure that we narrow the justice gap. And so it became important to think of a framework where people became, again, actors of their own justice, but not in isolation, working together with institutions such as the Court Users Committee, working with together institutions such as the national frameworks that we came to have later, working together with initiatives such as paralegalism and so on. So ultimately, with that in mind, a task force was put together, and I'm very privileged that I served in the task force alongside my sister, Jemimah. And in that task force, we posed several questions that helped us to craft a policy. And the essence of that policy is very basic. It picks up the key instruction from the Constitution, which is that judiciary is being invited to promote, and I'd like to request us to underline that word, to promote alternative models. And so what the policy does is to unbundle what is to promote. And that, so the policy is not about controlling or regulating. It's really about just promoting AJS. And that's the background, and that's the kind of a policy that we have in place. And so our committee now was appointed later on by Justice Maraga, and extension received from Justice Martha Koome to implement that baseline policy developed in the era of Justice Mutunga. Thank you.
Thank you very much, Daktari, for that background. And on the point of the justice gap and the need to narrow the justice in the eyes of the people, Jemimah, I want to bring you on board. And somebody may ask, is whatever work that we are doing, does it have the policy, the legal and constitutional framework? Jemimah?
Okay, thank you so much, Moderator, and thank you for the great introduction, Daktari. The mandate of NACI AJS and the work of the AJS policy begins from Article 1 of the Constitution, which grants the people the power to be able to make, to delegate whatever they want in terms of legislative power or legislative authority, judicial authority, and also executive authority. In that delegation, in terms of judicial authority, they've delegated the power to decide disputes and cases to the judiciary. However, when you look at Article 40, this power, they can do it either directly or indirectly. So the fact that we have the judiciary, that's the delegated power. But remember, they still have the opportunity to exercise their own agency in terms of deciding their own disputes. And whatever judiciary is doing is the delegated mandate. When you look at Article 48, it talks about access to justice. So these same people have the within the Constitution the authority to get the power to get justice, and without any technicalities. And this, you look at Article 48, doesn't mention about justice being received from court. It just says the state shall ensure access to justice for all. And so whatever means that the people choose to get justice, they still align it under Article 48, which says that the state shall ensure people get access to justice, and not necessarily access to justice in court, but it blankly say access to justice without any due regard to technicalities. Having said that, we come to Article 159(2)(c). Now, the delegation that the people gave the judiciary under Article 1 comes in to Article 159(2)(2), Article 159, where now the powers of the judiciary to determine disputes is being categorically aligned. But you come to Article 159(2)(c), the judiciary is being told that you shall promote. It's mandated. It is like being told that as you look at the courts, as you look at matters that are within the court, but you shall also ensure promotion of alternative justice systems, including, and it lists all these other forums that the people can be able to get justice. It is from this background that the Chief Justice, through the STAJ, aligned now, they provided for the multiple doors of access to justice. Now, having the background of Article 1, the background of Article 48, and the background of Article 159(2)(c, then the Chief Justice comes in with the STAJ saying that we as the judiciary must ensure that people can get justice through all these doors, and provides the various avenues or the various doors where people can get justice. Meaning that the Chief Justice is telling the Kenyans, we should try to resolve disputes using any of these provisions or any doors that we have, not only aligned in the Constitution, but those doors that we, the people, feel can get justice. Look at the Constitution, the CPC and Article 18, Section 187 said that people should be able to resolve disputes, misdemeanors, outside court through reconciliation, and at the end of it all, when they come to court, the court can be able to allow the parties to withdraw the matters. We have the DPP, ODPP policy, the diversion policy, and the plea bargaining guidelines. All this gives opportunity for parties to be able to resolve disputes outside court through their own avenues and be able to come to court, or a link between the court to enhance access to justice under Article 48. Last but not least, from all these policies that I've mentioned, we now have the ages policy that was launched in 2020 during the Katiba Day celebration, the 10th Katiba Day celebration. What are the policy provide? The policy looks at all these provisions that we have that I've mentioned, among others, to be able to give avenues and provide the avenues within which parties can be able to resolve their disputes, not only through one channel, but through the various channels that we have. Thank you, Moderator, back to you.
Thank you, Jemimah. And the reason that we have you is to speak that gospel, especially. I hope my brothers and sisters from the ODPP are on board, and you have heard that indeed the CPC, the Constitution, and your own guidelines do provide for these alternative ways of sorting out criminal matters. The multi-door system. The Chief Justice is a big proponent of the multi-door system, the people-centered justice. And in her speeches, you'll always hear her talk about this. My Lord Justice Gikonyo, I want you to situate the work of the AJS and what AJS is doing, the policy and its implementation, in the broader vision of the Chief Justice under the judiciary. Karibu, my Lord.
Thank you very much, Bwana Njoroge. Before now, I married the STAJ and AJS. Let me make two important statements. That properly conceived, AJS expands rather than diminishing conceptualization and the practice of human rights. And the second statement I want to make is that AJS is about justice. And this was emphasized by Dr. Akoth, but with the potential of social transformation. And therefore, what Dr. Akoth would say, and I will repeat, therefore, it is the bulwark of STAJ. Having stated that, this multiple door approach, which has been adapted by STARG, forms the major foundation of enhancing access to justice. So STARG in itself rests on that idea of having multiple doors of justice as a basis for enhancing access to justice for all. And that is also in line with the SDGs, I think SDG 16 on sustainable development. So AJS, the way it has been formulated and focused by STARG, is making it one of the major forums which provides many avenues of people to seek justice. And that is in line with the Article 159(2)(c) of the Constitution, and also Article 48 of the Constitution, which talks about access to justice, and Jemimah said this, rather than access to court. And therefore, it really enhances people's autonomy to choose, because people have that right to choose under the Constitution where they will take their disputes for resolution. And again, I want to repeat what Dr. Akoth said, and the work of the judiciary under STARG is only to follow those people in their various spaces to promote AJS, to ensure that it is in line with the Constitution and is able to produce outcomes which are in line with the aspirations of the people. So therefore, STARG can be said to be an implementation tool of Article 159(2)(c) of the Constitution, Article 48 of the Constitution, and also Article 1 of the Constitution. So this idea of multiple door of justice is a big one, and as I've said, is very different from ideas of multiple doors in other jurisdictions, because ours is that the multiple doors are there and they emerge organically, constituted and run by the people, and they choose where to go. They are not being directed where to go. And therefore, that is quite fundamental in understanding how AJS works and how STARG moves it as the rolling tool of enhancing access to justice for all under Article 48 of the Constitution. So I would say that for the moment, but more will be said as we progress. Thank you very much, VC.
Indeed, thank you very much, Judge, and indeed we will come back to you so that you can demonstrate to us how judiciary has actually taken this role of promotion of AJS. But I want to go back to Daktari. And Daktari, Article 159 talks about three aspects. Talks about ADR, it also talks about TDRMs, and out of it, AJS comes into being. Very many people may not be able to differentiate, or they basically put together ADR and AJS, or AJS and TDRM. So I want you to debunk and demystify what these three terminologies basically mean, and how are they under an umbrella, are they on their own, and how do they work? Karibu sana, Daktari.
Thank you very much, Chair. You have just thrown the frog into the waters. That's a question I always like. And it's a very important question because, look, if you go to the United States, you'll realize that what you see in terms of the criminal justice system is the emphasis on the jury system. And the right to a jury is actually not the right of the accused. is the right of the public. But with time, the determination of criminal matters through the jury has declined, and what you see being utilized more is plea bargain. The word plea bargain is nowhere written in the Constitution of the United States or any other amendment. If you look at the history of one of the major atrocities that nobody wants to be charged with, which is genocide. The word genocide was first used in 1944, coined using a term from Greek, another one from Latin, by the famous Polish lawyer, Raphael. And so today we use the word genocide as a common lingua in referring to a particular kind of atrocity. I would like to invite you back to what Justice Gikonyo and my sister, Madam JEMIMAH, has anchored on, Article 1. The importance of Article 1 on the place of the people, the sovereign authority belongs to the people. It means, among other things, that the promulgation of our Constitution is an ongoing process. The promulgation did not end on 27th of August. No, the promulgation is ongoing. And Justice Mutunga, in a judgment through citation, I don't have in full details, made this very clear when he was, when they were determining the matter of, I think, three-third gender rule, and he kept saying that the promulgation is an ongoing process, and every time we practice the Constitution, we promulgate it. And that's also the idea of Article 259 of how to interpret the Constitution. I say that as a preamble because it really helps us to situate how to respond to that question. So with that in mind, if you look at Article 159(2)(c), the first thing that you should ask yourself is, what is the intention of that provision? Is the intention dispute prevention, dispute resolution, conflict prevention, conflict resolution? What is the intention? In our reading, you have to start by looking at Article 159(1), which starts by saying judicial authority is derived from the people. Now, then it goes ahead to help you to identify what is the purpose of judicial authority. And it outlines that the purpose of judicial authority is to enable actualization of Article 48. The purpose of judicial authority is to enable access to justice. And therefore it proceeds and gives the judiciary the authority to act based on donated power from the people. And then it goes on and gives qualifiers, don't emphasize technicalities, justice should not be delayed. And then it says in 2C that in doing that which you will be doing in exercising authority as a judiciary, you have to promote, one, certain methods. And there's a difference between methods and system. And I want us to get this clearly. And the methods are outlined as conciliation, mediation, arbitration, and alternative dispute resolution. These are methods. Then at the end of that provision, it also talks of a set of mechanisms, traditional dispute resolution mechanisms. Now, we do think that that last component of mechanisms allows us to come back and ask ourselves, when the people donated judicial authority, doesn't it mean that they have some residual power? Because you see Article 1 says you never donate authority fully, you can recall it. So there's some residual judicial power that people have. Now, that judicial power that people have is exercised not confined with the protocol of judiciary, but is exercised within a different universe. So there's another universe apart from judiciary universe. Remember, judicial authority is not equal to judiciary. So there must be other frameworks of exercising the same judicial authority. The term, yes, was first coined at Sportsman Arm Hotel by Justice William Mutunga, Professor Joel Ngugi, and myself to describe that other system that people use to exercise their authority and has got normative systems that may include the constitution, their culture, mystic powers such as a belief in supernatural force, and they exercise it from birth to death, and sometimes they also use it to resolve disputes. Sometimes they use it to resolve disputes. That is what we call AJS. So that the difference therefore between ADR and AJS is that while ADR is a method that you can use within the judicial system, you can use within the AJS system. Mediation is a method. Arbitration is a method. But ladies and gentlemen, we must not forget that Article 159 and the entire corpus of the Constitution invites us to appreciate the kind of legal pluralism that we have in our country. And that pluralism therefore means that there are multiple universes around which judicial authority can be exercised. And we do coin the word AJS. Let me finish by explaining why JYS. When we call it alternative, we don't mean to say that it is inferior, evolving, or in some waiting room. We simply mean that we have already created the center. The people have created the center, just like we have created the center of executive authority. So I cannot come and say that I am the president and I have to exercise judicial executive authority. I can be, yes, a people's president and so on, but that's different. We have legislative authority, and I can't say that now I'm going to be the speaker. You can have bunge la wananchi, but bunge la wananchi cannot enact statutory laws that then would apply anyway. They can do their functional thing. So that applies also to judicial authority. So we call it alternative because of that constitutional hygiene. We call it justice because, as I've said, sorry, Chair, and thank you for the indulgence. We call it justice because the role outlined in Article 259(2)(c) is not limited to dispute resolution. It is limited to a larger gamut of action, which is implied in Article 48. And we call it system. Why? Because it envisages a particular universe, way of thinking, way of relating. And remember, it is an open system. Being an open system creates a distinction between AJS and customary law. Customary law, the way of practice in this country, is a closed system. You follow, a particular template, and you say that this, template is a reflection of a Kikuyu customary system, Luo customary system, and so on. And you know the limitations of that. And finally, Chair, AJS does not, and the notion of tradition there does not only refer to tradition as an ethnic idea. It refers to tradition as that practice that people have gotten to use, have an authority of using, and have become part and parcel of the way they do business in that segment. In engineering, you have certain frameworks that almost form a tradition. In architecture, in the marketplace. So that idea of tradition moves beyond anthropological tradition. Thank you,
Chair. Thank you very much, Dr. It's always a pleasure to hear you talk about this, and that is why I indulge you to extend a bit of time, because you really demystified very well. I hear you saying that the tradition is not the tradition traditionally known, but it is tradition of the modern. We will come back to you and we seek to know, how are the practitioners? Are they old men and women, or who are the real AJS practitioners? So thank you for that, for demystifying models versus systems. Closed system, which is TDRMs, versus open system, which is AJS. Asante sana. On that note, We've had the AJS policy form, which was promulgated in 2020. It is in the stage of implementation. JEMIMAH is at the heart and the engine of implementation and rolling out in the country. So JEMIMAH, I want to bring you in at this point so that you can talk about what is the implementation strategy of the policy and what is the progress. Can you give us some data and statistics of how far we have gone in terms of implementation? Karibu sana,
Thank you
JEMIMAH.
so much. Thank you so much. Thanks, Dr. for demystifying the use of alternative and the difference between ADR and AJS and the issue of the tradition. So first of all, appreciating that tradition is not the old way of doing things as people have in notion, but tradition here in stands in the custom that people develop to be able to be dealing with disputes over a period of time, and it becomes a culture. For instance, the lawyers have a culture, the way we do our things, from even standing with people. I was being told that we are the best in terms of our profession, in terms of supporting one of our own in a bereavement. And so it's a custom that we've come with. So for the implementation of the policy, we appreciated that. We appreciate that the communities had developed their own ways of doing things according to Article 11 and Article 19.2 of the Constitution. And our strategy is not to break what they're doing, but to be able to support what they're doing. And so we work with different stakeholders, of course, the main one being the judiciary by virtue of Article 159.2c, because they're the ones that have been given the mandate to promote alternative justice systems, promote all those doors that I mentioned earlier, so that you can realize SDG 16.3. So we work with the judiciary hand in hand in terms of through CUCs, through court users committees in various counties. So we come to the county, we identify the stakeholders, either through training, awareness creation, and sensitization. The second way is now development of the county action plans. So through the CUC, we are able now to work with the county governments to develop county action plans. We realize that different counties are very unique. They have their own justice issues. They have their own traditions in way they resolve disputes, and they have their own stakeholders whom they work with. You can find a county has a strong presence of CUC in terms of dispute resolution, like Mombasa. There's some counties that have a strong presence of the chiefs, like in Nyeri, who have been instrumental in resolving disputes. There are some counties who are using elders, for instance, in Garissa, Kajiado, and Isiolo, northern parts where we're using the elders. And so we have to develop different models depending on who are the stakeholders and what are the justice issues. So far, we've developed 10 county action plans and launched them. That is Turkana, Trans Nzoia, Uasin Gishu, Kisumu, Narok, Nakuru, Kajiado, Isiolo, Marsabit, and Mandera. We are now working towards launching the other 4 that in the next 2 months. That is Mombasa, Siaya, Garissa, and Kisii. We have also 4 that are on the pipeline, including Homa Bay. And so we developed the county action plans. Through the county action plans, we're able now to enhance access to justice for the people according to Article 48. I've talked about training. We do trainings. Our trainings last for 3 days. We've trained all the Supreme Court judges. We have trained all the Court of Appeal judges, except for 2. We have trained all the High Court judges, except for the 20 were sworn in last year. We have trained about 105 magistrates, including the deputy registrar. So that's why we have a gap. We've worked with the civil society and conducted about 20 trainings of various civil society groups across the country. We've trained refugees in the different refugee camps, that is include Turkana, Nairobi, where we have the urban refugees, and Mombasa, we have the urban refugees. And this year we'll also be going to Dadaab. We've also been able to work with the chiefs, and so we've had a training with the chiefs in Othaya, but working towards having another one in Baringo. We've trained the senior officers of police officers and 40 senior prosecutors. We still have a gap in terms of training. However, in terms of awareness creation, we've held 3 webinars with the Law Society of Kenya. We've held webinars with all the judiciary. We had 3 webinars last year. Last but not least, our strategy is also to have AJS conferences. So as you've all had or participated in annual AJS conferences, through these AJS conferences, we just have foster a place whereby people can share conversations on justice from different counties and countries. So we've had 3 conferences so far, and we're looking forward to the 4th one next year, which is likely to be in Embu. And through these conferences, people are able to just have a discussion on how their justice systems are working, because we are still talking about the traditions. What traditions have they adopted and how are they working? And we're looking forward to the 4th conference to be able to now share our strategy, do the mapping of what has worked, what is not working, and what can we do better. Back to you, moderator. Thank you.
Thank you very much, JEMIMAH, for crunching the statistics in terms of implementation. Ladies and gentlemen, participants, you can see that the committee has indeed been quite busy. JEMIMAH, allow me to stick with you because there is a question that has been asked, and I want to throw it to you. This is Dorothy. Dorothy, thank you for your question. She is asking, for counties where AJS has been launched by the CJ, do the respective counties have their own AJS county action plans? What information does the county action plan contain, especially with regard to ensuring that the right to fair hearing is promoted, advanced for disputes being resolved through AJS?
Okay, thank you very much, moderator. Indeed, by the time we are coming to launch something called a county action plan, it's an action plan, it's like a strategic plan. We have gone through a series of sessions with the CUC and the stakeholders to be able to develop that county action plan. It's actually a book that we launch, and we open an AJS center called an AJS suite. So in all these counties that I've talked about, the 10, we have 10 different county action plans with different models of AJS, looking at how they're able to implement. So it's a whole system of doing justice survey, collecting the data about the justice issues of that particular county, then meeting with the stakeholders to discuss what works, what does not work, who are the key justice players in that area, and then we draft a model and an action on what activities we can do for the next 3 to 5 years in terms of implementing article realization or towards realization of Article 159 2C and the people-centered justice. So I think that answers that particular aspect of whether we have launched the counties. In terms of implementation, we do quarterly reviews, monthly monitoring, monthly, quarterly, and annual follow-ups and reviews of what is working and what is not working, and now we can be able to make it better. So this year we went across the country in the various counties that we've launched to be able to have strategic discussions with the partners and the stakeholders on how can we enhance use of AJS. I didn't share statistics. I'll share briefly about the statistics. In terms of Othaya, last year we had 187 cases that were resolved. In Nakuru Law Court, we had about 100 cases resolved through AJS. This is the court annex model. In Isiolo, whereby we're using the elders, we had 150 cases resolved. In Kisumu Law Court, because we just launched it last year, we had about 76 cases that were resolved through AJS. Kitui Law Court, we're using the prison model where people have discussions within the prison. We had 28 cases. Kajiado, we were dealing with land cases. Across the county, we had 366 cases. In Narok Law Court, it was launched last year. We had 18 cases, and in Mandera, which practices mainly the Masla system, we had 182 cases that were resolved. Thank you, and back to you, moderator.
Thank you, JEMIMAH. I hope, Dorothy, you've adequately been answered on that. What is the role of the judiciary? You may wonder that looking at AJS being out there and the people organically sitting down and resolving their disputes on their own, what would be the interaction with the judiciary? People may ask, what is the end result? Is it enforceable? Is there any mechanism that there can be an end and actually enforceability? My Lord Justice Gikonyo, I want to bring you on board so that you can tell us more about the role of the judiciary and the doctrine of interaction. Karibu sana, my lord.
Thank you very much, Moderator. You have used a technical term, doctrines of interaction. I think it is important they know what we mean.
Yes,
by that.
Yes.
So it simply means when the courts come into contact with the AJS resolutions, how do they behave or how do they respond? Because the role of the judiciary generally is to ensure that it is responsive to AJS and AJS resolutions. So I'll be discussing that within that context so that you understand what it means and how it can be used to promote AJS or to hurt AJS. So there are doctrines of interaction which are contained in a policy as a result of fact-finding and information gathered from decided cases on how courts reacted to AJS resolutions. And Njoroge, I cannot see myself in the screen. What is happening? Is there something I've not done on my side?
No, Judge, we can see you very well. You are with us.
Can see me. Sorry,
Yes.
sorry for that. So let me continue. So when we dug the old wells of court files, we found out that initially judges used to ignore AJS proceedings and awards on the basis that they do not have jurisdiction to deal with those matters they dealt with. And that kind of interaction was given the name avoidance. So you ignore it, you avoid it completely, and you don't attach any value to it. But now when you gauge that against the Constitution and what it requires of us to promote AJS under Article 159(2)(c) of the Constitution, you find that that kind of interaction with AJS and AJS outcomes or resolutions is unconstitutional. So we want to use what we found out to be able to educate the judiciary and also the legal profession on what is unconstitutional and what is good and acceptable under the framework which we have under Article 159(2)(c). So that kind of interaction would be unconstitutional. The other way of interaction which we found out, we called it monism. And this is where they assume that the court assumes an apparent role over AJS resolutions, and thereby allocating itself powers of interacting with the merits and the law. And that was quite contrary to what was envisaged to be the role of the court under Article 159(2)(c) of the Constitution. Aided AJS and the courts, and this was well articulated by Dr. Akoth. So to me, they work outside the court and hand in hand without really placing the court above AJS in the sense of appellate jurisdiction. And when you look at the system of courts, there is a clear hierarchy getting outside courts, but is part of our judicial and legal framework to resolve disputes. And so when you that kind of power as a court, the other way of interaction is called and once that resolution has been made by AJS mechanism, then it is complete in itself and does not require the consent of any of the parties for it to be adopted by the court or to have effect. So you find that will be giving one party veto power of AJS resolution, which would be against the Constitution. So we also say that is not a good interaction. There is also another one, which we call facilitative interaction, where the court says that AJS will be treated as part of evidence or one of the pieces of evidence in the final determination of the matter. But that is problematic because if a matter or an issue has been fully resolved through AJS, then it is complete in itself and should be adapted as settling that issue. However, this one we don't say it is unconstitutional because you may find AJS resolving some and not all the issues. So in that case, those issues which have not been resolved, then you can consider AJS resolution as part of evidence. So we say in certain circumstances, it may be good, but not in all circumstances. So we say it may be used, but with that caution. There is also another one, which I will combine, difference and recognition and enforcement of AJS mechanism. So that borrows from the practice within arbitration, where you come to court for recognition and enforcement of that award. But what we prefer most is difference to AJS mechanism, total difference to AJS mechanism. And you only check for only two things under the power of review, not appeal. You check whether AJS process and resolution took or adheres to procedural propriety and constitutional proportionality. Then on only those two grounds that you have the power of review. And that has a constitutional backing under Article 159, sub-article 3 of the Constitution, where it sets the outer constitutional limits against which you gauge a resolution. That is the only intervention that the court can make. And once you find that the resolution is quite in line with the Constitution in both of those two tests, then you have no choice than to adapt it. It becomes enforceable. So I think I've made myself clear, but in the event of any question, we are here to answer it.
Thank you, Judge, and indeed for demystifying the doctrine of interaction. And ladies and gentlemen, participants, you can see that this system of AJS is foolproof. It is back-to-back from the initiation to the end. There is no gap that you can find in the process itself. Judge, I want to stick with you because I'm blending the questions that are coming in. I know you are a trained mediator, and you know the interactions with the court annexed mediation, and I thank my fellow mediators who have joined and they have asked a question. I see the question by Margaret Wamboi, mediator. What is the role of court annexed mediation and mediators in AJS? I want to combine that together with another mediator's question, Jennifer Ngeru. How can AJS and mediation work together? Briefly, Judge, just address those two.
Thank you very much. Those are important questions. If you listen carefully, the explanations which were given by Dr. Akoth about AJS, what it means, and the place of methods such as mediation, then you will see how they relate with each other. AJS is the system, and then these other mechanisms like mediation is part of AJS. And so you should not look at them as if they are distinct. Look at them in the relationship of a system and parts of the system. So AJS becoming the system under Article 159(2)(c), and then under the same article, mediation being one of the parts or mechanisms through which disputes can be resolved. And therefore, they have a role within AJS. In fact, they are part of AJS. So in my view, that's how it should be looked at. Only that when you have a court annexed, then you have a kind of typology of mediation, which is connected with the court. In fact, it does not become the court. It is only connected with the court because of the way it has been formulated. And it's one of the typologies. And I think when we shall be dealing with the typologies by JEMIMAH, then the whole concept will be understood better. So court annexed mediation is not the court. So it remains quite separate, and it operates within the ordinary rules of AJS, which I have articulated that they are separate outside the court, and whatever they resolve is complete in itself. But maybe perhaps what I should explain is that it is because of the referral mechanism which has been developed for court annexed mediation, which maybe bring in that confusion. But it is still one of the AJS mechanisms. And once a matter has been referred there, then the mediator gets full control of the matter together with the parties themselves, and whatever resolution they get, as long as it adheres to the outer limits of the Constitution, then it is complete in itself and enforceable in law. What was the other question, Njoroge?
Yes, I think they were related. I think you have.
They were related. I think yes. I've answered both of them together.
Thank you very much, Judge. I hear you saying, and actually in actual practice, you'll find that part of our AJS practitioners, we draw a lot of a number of them from the from mediators. So mediators can also are welcome to AJS field. Once you're trained and you get to understand the mechanics, then you can be able to join in. There is also a question by Okina James. Just be looking at that. I will come back to you. It's about on the interaction that you have just talked about. But I want to go back to our philosopher and Dr. Akoth. People may wonder, why a people-centered justice? What is the rationale behind that? And I want to marry that with a question that has been asked by my good friend, Chartered Arbitrator Paul Ngodho. Paul Ngodho has posed this question. Capital punishment is allowed in the customs of various traditional communities in Kenya. That is particularly so for the theft, murder, and witchcraft. It has become common practice for boda riders in certain places in Kenya when they apprehend a motorcycle thief to hear the case, find him guilty of theft, and lynch him immediately. Is this classified as AJS or TDRM? Why or why not? Daktari, as you tackle the question of the people-centered, the people are given this power. What is espoused in it, and how can they use this power in the bigger objective of AJS? Karibu, Daktari.
Thank you very much, Chair. Yes, indeed. First, so the people give themselves that power. So the people give themselves that power. The Constitution recognizes it. Why is it important, as you've asked, in the framing of access to justice? And this is very important. It's true sometimes I like philosophy more than I should, but look, know that most of us here are lawyers. It takes us back, in fact, to the question of the theory of the state. Because you see, there is this fiction that, you have this Leviathan, and you give this Leviathan, you donate to this Leviathan powers, and this Leviathan then can protect you. AJS reopens that conversation. And it says that people have got two things, needs and capabilities. People-centered justice is just about that people have got needs and capabilities. They have needs, justice needs. What do they want to see? The idea of justice, and they want it resolved. But also, which is what that Hobbesian thinking doesn't take into account, people also have capabilities. And sometimes they have developed the way of doing it. Take, for example, if you go to informal settlements like Madari, you have a dispute where neighbors have a conflict because one neighbor is making noise because the wall between them is corrugated iron sheet, and their beds are all aligned on the same corrugated iron sheet. And therefore, there's a little bit of a nuance coming from one side to another, yet all of them are squatters. So what claim would they make? One cannot make claim that another one is denying them the comfort of enjoying the right to property because they are both squatters. But there's a major justice issue here, which within the customs, within the culture of living in that area, they know who is the violator and the threshold of the justice question, and have the capability of solving it. If they took that matter to court, most likely the outcome that they would get, first, the court will not even understand what the issue is, because the issue that they're calling the justice issue is not understandable in law, because the law is framed from a particular universe. But them, they have a capability of framing it in their own universe. If you go to the fishing folk, you see the same. If you go to upmarket area like Karen, you see the same. If you go to a place like where I belong with the people of Mercedes drivers, you see the same. There we have a culture which Toyota drivers may not understand, for example, on a light note. So this capability issue is very important. The second issue, why people-centered justice is important, then it poses the question, justice for who? Whose justice? Whose justice? Sometimes for somebody, justice would just be an apology. Sometimes justice to somebody is guarantee of non-repetition. Sometimes somebody justice would be restore of honor. Often these are never conceptualized in our common law idea of justice. And this is not new. If you study the history of common law, the emergence of the law of the court of equity was exactly because of that limitation in our common law. And the emergence now of traditions like AJS, or rather the recognition of these traditions, is because we now know that it is not possible to amalgamate those people's idea of justice into our common law framing. So that is essentially the importance of that. Then back to the question, does everything go? Justice Gikonyo has referred us already to Article 153, Clause 3, which gives the outer limitations, including any act that contravenes Bill of Rights cannot be called AJS. So if you are more violent, it's not AJS at all. Any action that is repugnant to morality cannot be called AJS. And we are careful. We don't like the word repugnant to morality because of its colonial history, because it doesn't answer the question, morality, whose morals, repugnant to whom? But because the Constitution cannot contradict itself, we argue that the idea of morality here is any act that runs afoul to our values, which are outlined in, among others, Article 10 of the Constitution. Then any act that is consistent with the Constitution and written law. Yes, there's capital punishment, but we know that somebody's life can only be taken away lawfully. That means that AJS does not have the legal power to take away anybody's life. So all those acts of violence, acts that fall outside the borders of human rights and dignity cannot be called AJS. Allow me, now that we've not come back, Chair, to give a preamble to Justice Gikonyo, to a question that have been floated in the chat. And that's a question which we look at in detail. The question is, can AJS be undertaken after a matter has been canvassed in court? And can AJS proceedings supersede or replace court judgment? This is a very important question, because you, Chair, you made a very important statement in the beginning that you must see AJS within the continuum. When I talk to students, I always tell them there's a difference between seeing AJS within a continuum and seeing it within spectrum. Spectrum is like the rainbow bands, which do not have organic interaction. But continuum, especially circular continuum, allows for a relay system. So the answer, therefore, is, can you deal with matters which have been determined in court through AJS? The answer is yes. Yes, because courts of law determine matters, decide matters. But what people want is justice. Justice is not where you have a winner on one hand and a loser on another side. Justice is a more relational question. And therefore, this potential that even after a court of law, and it happens in most cases, after a court of law has determined a matter, there's still the need to go for AJS. Justice Ngugi keeps telling me of what he experienced in Kiambu when he was presiding judge in Kiambu, where after a matter has been determined in court, most of murder cases, if it is decided that it will not be a murder, matter is a manslaughter, and the person is released after serving their term, often there is another set of rituals and communal exercises that are meant to remedy what went wrong. And that is the idea of justice. The second part of the question, is it possible for decisions made in AJS to supersede the courts? Of course not. That's why we're calling it alternative, because nobody can oust the jurisdiction of the courts. Because we, as a people, have created the court as the default institution, and nobody's right to access our courts can be ousted by any other mechanism. So a continuum idea, yes, where a matter decided in court can be canvassed again through AJS, but ousting the court jurisdiction, no. Thank you.
Thank you, Daktari, for breaking it down. And indeed, participants, it is determination which is done by the court versus resolution, which can be found within the alternatives. You've had the power of the people. Paul, I hope the question has been answered by Daktari in many words, and anything that is unconstitutional, then it is outside the scope of the AJS. So we may not call it AJS. Indeed, no human is limited, needs and capabilities, as Daktari has well put it. JEMIMAH, I want to come to you. And as I pose this question by Laken Esquire, Laken asked, who trains AJS, and does the said AJS framework have some regulatory framework, just like mediators and arbitrators? As you cover that, I also want you to just take through the participants the aspect of the monitoring and evaluation of AJS. Do we have a tool? Are we able to monitor and evaluate how, what is the justice that is being meted out? What are the statistics and what is the outcome of it? Are the people, by the people, happy? Karibu sana, JEMIMAH.
Thank you so much, and thanks, my fellow panelists, for quite insightful discourse here. Regarding on who trains the AJS practitioners. So first of all, we have the National Steering Committee that has a membership of 25 committee members drawn from the judiciary, the ODPP. Your Highness here, David represents the Chartered Institute of Arbitrators to the committee. We have representation from the probation, civil society organizations, the National Police Service, among others, and including the Council of Elders. So these committee members, most of them participated in developing the policy as task force members before they became committee members. So the training is done, first of all, by the committee members. However, we've adopted a TOT model whereby we work with various organizations to train their stakeholders. For instance, civil society organizations such as FIDA Kenya, Pamoja Trust, Kituo cha Sheria, Helene. So we've been training most of their practitioners as trainers so that they can be able to also cascade the trainings to other people to the village level. So that answers the question on who trains. We have a training curriculum and a manual which we use. And so by the time that unstandardized PowerPoint presentations to be able to guide and ensure that the information that is being shared across the country, actually we have the bare minimum information that must be shared with the trainees. In terms of regulatory framework, we have guidelines that we've developed as a committee, guidelines to be able to guide the autonomous. The autonomous are the ones that we always talk about, the elders, the community leaders, the people who deal with justice issues at the family level. So we have guidelines that guide on how the bare minimum standards in terms of selection of the panelists and how they're supposed to conduct themselves and what can lead to disqualification. We also have some of them who deal with disputes, for instance, like the DPP, which will be applying the version of plea bargaining, as state officers or non-state actors, civil society actors, they've also been, they also operate within their own code of conduct. For instance, for us as LSK members, whether you're a mediator or just as an LSK person, you have a code of conduct that you need to be able to operate within. So not only have we developed our own guidelines, but also we ride on the code of conduct from various institutions or agencies that already exist at the CUC level or any other stakeholders that we are working with to be able to ensure that we operate within the human rights framework that Dr. Akoth has alluded to. In terms of monitoring and evaluation, yes, we are doing monitoring of various ways in which justice is being, the AJS policy is being conducted. And I had mentioned this earlier, I believe. Working with we have secretariats from all the counties that we have launched the action plan. The judiciary and the county government have been able to support AJS policy by having a secretariat. Also, other stakeholders who have either as an intern who can be able to have volunteers to support the secretariat. So through the secretariat, we're able to collect the data on trainings that are happening in that particular county. What are the needs of that particular county? How AJS is being conducted, the cases. That's why I was able to share with you data on the cases that we were able to do last year. This particular time is when we're working on the SOJA report that will give us now the data for this year. So in terms of that, we have the statistics. I believe I've been able to answer the 3 questions. In case there's any, maybe you can let me know if I've missed out any. Thank Thank you.
Indeed. Thank you very much, Jemimah, for that. Indeed, we have a monitoring and a very vibrant evaluation of the work of AJS. Judge, I want to move to you, and I want to tie in the question by Okina James. Okina James asked, to tag on the doctrine of interaction, the notion of good and bad varies from traditional perspective vis-a-vis the judicial modern. How do we balance this variance? As you answer that, just also tackle the question of what is the jurisdiction of AJS? And also, because I see very many lawyers in the House, they would want to see AJS in action. How has the court, in terms of precedent setting in this area, has adopted AJS? Karibu sana, Judge.
Thank you very much, Njoroge. I think let me start with the jurisdiction of AJS before I come to the question of good and bad. So that is a fundamental question in law, and I know lawyers will be interested in this because they know that jurisdiction is what they call sine qua non adjudication of any matter by the court of law. It also applies in AJS. AJS must have jurisdiction in order to preside upon a matter. So where does it draw its jurisdiction from? We start with the Article 159, 2C. And then we also look at the right to choose and the party autonomy, to choose where to take your cases, which is granted under the Constitution, to the people themselves. And we were told by Dr. Akoth that under AJS, the people who come are not seen as mere justice seekers. They are also actors in their own processes and causes. So when you look at that, then you ask yourself, how will you determine whether a matter is fit for AJS or not? And based on a party autonomy and the exercise of a party's agency, that's their right to choose. Then the committee came up with the idea of agency theory as jurisdiction regulating principle for AJS. And they developed a two-tier test so that you're able to tell whether AJS has jurisdiction or not. And the basis of this, and you will see when we shall be analyzing this jurisdiction regulating principle, is that the Constitution does not give any characterization of cases as criminal or civil or sui generis or something like that. It doesn't give that in the first place when it comes to Article 159, 2C of the Constitution. It doesn't also say that it is only civil cases which can be tried by AJS and not criminal cases, or vice versa, or something of that kind. The Constitution doesn't give that kind of characterization or direction. So in this two-tier test for jurisdiction for AJS, there is a first part which we call positive test. And that's where we check, based on exercise of party's agency and autonomy, whether the party with the capacity, underline that word with the capacity, has consented to submit to AJS. So volition is key here. And the decision to consent is informed decision. And must also be made by a party with the capacity. And that's why you will see that matters to do with children or defilement or something like that may not really be part of AJS because of that element of lack of capacity. If a matter passes that test, you see that the party had a capacity and conscientiously made a decision to submit to AJS, then you go to the next test. And the second part is negative test. This requires you to check whether there is any constitutional or statutory or policy provision which owes the jurisdiction of AJS in respect of that matter. And you must tick all the three boxes, and I'll explain why. When you check the Constitution and you don't find any, it doesn't mean that there is no restriction or hosting of jurisdiction in the statutes or in policy provisions. So you are required to go to the next level of statute, and you check whether there is any statute which restricts or hosts the jurisdiction of AJS in respect to that matter. And I can give an example which is clear and common. When you go to Sexual Offences Act, they have clearly indicated that matters to do with defilement are not subject to any AJS resolution. And mainly it's because of capacity and also the need of the people through their legislative enactments, through their elected representatives, where they have expressed the seriousness of defilement and the need to deal with them firmly. So that is an example of statutory restriction. So if you don't find any, by the way, if you find any at any of these stages, then the matter is not good for AJS. If you find it when you're examining the Constitution, then the matter ends there. If you find it when you are examining the statute, then the matter ends there. But if you don't find any in the Constitution or statute, then you must check whether there is any policy expression which owes the jurisdiction of AJS over that particular matter. And again, if you find any in the policy expressions or provisions, then the matter cannot go to AJS. But if you do not find any, and the party had the capacity and made conscientious decision to submit to AJS, then the matter is good for resolution by AJS. So that is how you determine whether AJS has jurisdiction over a matter or not. Njoroge, do I proceed with the other one? With the other
Yes.
issue of decided cases?
Yes, proceed.
Okay. So I've tackled the question of jurisdiction. Now let's go to AJS in action. This is, in a sense, would mean that whether there are cases which have been decided through AJS and have been recognized by the court. And the data is there, and I know Jemimah, you will share that data at the end of it all. But I may share some few specific cases where AJS resolution has been used and recognized by the court, thereby determining the matter completely and effectually. I want to start with the most current and coming from the Court of Appeal. And that is number, let me see where I noted it. Yes, that is a Court of Appeal number 006 of 2025, where there was a serious dispute between the church members of AIC Church, and that was in Kisumu region. And the dispute dragged on for quite a while. But AJS was invoked, and a panel of eminent elders was constituted to resolve that issue, which was quite deep amongst the members of that particular church. And it was headed by the chairman of the National Council of Elders, retired Major Sei, and other elders from the Luo community. And they sat and they really evaluated the real grievance. That's why Njoroge keeps on insisting that the court determines cases. They don't resolve anything. They don't resolve the grievances which are underlying. And those are the undercurrent which sustain cases in court for years. But AJS focus on that. So they were able to discuss the issues, and eventually they made a report resolving all those matters and agreeing on how they are going to demarcate the regions. And the parties agreed to it, signed it, and filed it in the Court of Appeal. And then the Court of Appeal, on the basis of that AJS report and resolution, marked the appeal and all applications which were before it as completely settled. Now you can see the power and the magic of AJS. Deep-seated grievances are able to be resolved. And I think the secret is because of that question of having these parties as actors and not merely justice seekers. So they feel they are part of the process, and therefore they own the outcome, and they are able to live with it. There are several other matters. I'll not give details. There are several land case matters. There's Kitul. There's also Katel, where there were disputes between the siblings, and they had meetings within their families and the chief. And when those resolutions were brought to court, they were adopted by the court. They had been done much earlier, several years before the case came to court. But the court gave them okay, stamp of okay, and they were able to resolve a matter which had been lying in court for very many years. And I can give another one, succession, course number 3 of 2022. And I think I'm the one who did this one when I was in Narok. It was also a protracted family and succession issue. And the parties agreed to go to AJS. They resolved the issues. But I want to raise something which is quite unique in this case, so that you will understand better how AJS operates and relates with the court. Those parties who are unhappy with the decision, although they had signed the decision, then went and formed their own AJS resolution again amongst themselves and those parties who will be able to give them a decision in their favor. And then they did another one and also filed in court. So when I looked at both of them, I saw the one which was sanctioned by the court and all parties were involved and they made a conscientious decision to go was the first resolution. And I said very clearly, it is the duty of the court to protect AJS from such unscrupulous parties or third parties. So that is also part of the role of the court. And I also said that once you submit yourself to AJS, you have no right to abandon it and constitute another unlawful AJS for yourself. Otherwise, it makes whole nonsense of the entire process of AJS. There are several other matters, but because of time, Njoroge,
Yes.
I think, let me end there.
Thank you. Thank you very much, Judge. And the importance of those cases, especially the Court of Appeal one, is the binding nature that it has. And we are happy that after the judicial trainings that JEMIMAH talked about and capacity building of the judiciary, we are starting to see even higher courts, the Court of Appeal, the Supreme Court embracing AJS, which is very, very good. So lawyers, you have a binding precedent to use for AJS. Dr. I want to come back to you. And I know this is one of your pet areas. And I want you to further demystify this duty that it is so solemn and given to the judiciary, and how it basically transforms the aspect and practice of AJS. Karibu sana, Daktari.
Thank you very much, Chair. And thank you for always making my work very easy. Now, that question should be understood in a context where we are at. And this is very important, colleagues who are here. We are in a situation where a draft dispute resolution bill is out for public conversation. I imagine it's not yet tabled in the National Assembly. I think it's a private bill. Now, let me start by saying that that bill is also crafted to be an effort to implement Article 159(2)(c). I want to suggest that we have to appreciate that there are many children of Article 159(2)(c). Diversion is a child of Article 159(2)(c). The mediation is a child. AJS is a child. Arbitration is a child of Article 159(2)(c). Now, how is judiciary supposed to ensure this relationship? And what is the role of judiciary in this relationship between these children of Article 159(2)(c)? The Constitution uses the word promote. In fact, explicitly, if I may read, it states that in performing its judicial function, alternative forms of dispute resolution, including, and the methods are given, and what is instruction? The instruction, as was rightly highlighted by JEMIMAH, shall, we know the meaning of shall, mandatory, be promoted. So the key word here is promote. What is to promote? Promote is a word which is borrowed from the human rights lingua. And in that taxonomy of human rights, it's embedded with the notion of develop, improve, enable, let it be better, let it grow. So therefore, the policy that we developed and has been promulgated by the judiciary has divided the word promote into three major duties. That the obligation to promote implies a duty to respect. So you cannot refer to AJS as kangaroo court, for example, or something of some old people or people who have not gone to school. That is unconstitutional. That is not promoting. You have to respect it. Secondly, you must protect it. Judiciary has a duty of protecting AJS from third parties, and Justice Gikonyo has just given you an example where a matter is resolved using an inclusive AJS system. Then another team gerrymanders and gets another compliant team and makes a conclusion in their favor, and then they confront the court with that. So what Justice Gikonyo is saying, the court will look at the genealogy of the issues, and based on that, see really who is mischievous. And the mischievous one then must be called out, and the one against whom mischief is being directed must be protected. So the role of judiciary to protect AJS from third-party legitimate interference. The third duty which we have extrapolated from the word promote, is a duty to transform. This is very important because AJS is not a perfect system. How can it be while the judiciary itself is not a perfect system? I was reading last week the report from Transparency International on corruption, where they highlighted that corruption is rife in this country, and the place where the unit of bribe per individual was highest, according to the perception survey, was in the judiciary. That means judiciary, whether factual or a matter of perception, is struggling with the question of corruption. Even the executive, the legislature, is not perfect. So we must therefore, as a part of duty, imbue an ongoing effort to transform AJS mechanisms to make them come in tandem with the constitutional requirements, so that they don't oscillate in a manner that deviates from the constitutional requirements. And that is why, as Jemima said, our ongoing trainings and engagements have become very useful. But I would also like you to take another note. This transform is also pointed to the courts. The court must transform. And Justice Gikonyo just illustrated how the court must transform in their thinking, in their practice, in their articulation. And if the court transforms, it means the officers of the court, who are yourselves, must also transform in terms of the attitude, the practice, and framing. That we frame our matters, we engage in a manner that promotes AJS, and that means that we consistently move towards enabling it to practice. So that is really the meaning of this duty, to promote and even bundle it in that multiple form. Thank you. Back to you, Chair.
Thank you, Dr. Participants, you have had the solemn duty is basically targeted at changing the attitudes, the culture, and the practice of the judiciary. And we are happy, and we must commend the judiciary because it is coming on board very, very well. And as you have heard from AJS in action from the judge, that matters are actually being taken on a transformative nature, and the bottom line being whose justice is it, and gearing towards ensuring that that justice is achieved. Asante sana, Daktari. Coming to you, Jemima, there is that question about when it is people-centric, who chooses these panelists, and how is the principles, our solemn, cherished constitutional principles of diversity, equity, inclusivity, how do we achieve this in AJS in action? Karibu, Jemima.
Okay, thank you so much, Moderator David, and thanks, Daktari. First of all, I'll start from the case where the judge talks about the Court of Appeal case. So in this Court of Appeal, when the court referred the matters to the AJS panelists, at least they directed that the chair of the Council of Elders and then any other elders within Kisumu County who understood or had an understanding about the genesis of the matter should sit to be able to handle the case. So if it's one that is being referred to the court can direct, because of specific expertise that somebody has, the court can direct that this is the panel that they want and be able to just allow other people to join in. That case was involving churches and it had been in court for 10 years. But now through one sitting, 10 other matters that had been filed in the magistrate court and in the high court were handled at that particular sitting through that one case that was in the Court of Appeal. So we have the court annexed, whereby the panelists, it's a pool of panelists, the way we do mediation. And in that pool, the secretary is able to look at the expertise of the kind of person they want in a matter. For instance, in succession matter in Nakuru, whereby it involves perhaps people from one ethnic community, they feel like there's an elder who needs to be here, and then other people. Maybe it's a matter that relates to family. So we have somebody who has an expertise in children matters who can sit. That's one way in which we handle AJs. The second AJ is the one that we call third-party state actors. Third-party state actors means the people who are working with the government institutions of the state. By virtue of the work, they also deal with dispute. For instance, the chiefs that we have, our probation officers, the children officers, the police, so many disputes are resolved at the police. So we are not choosing the panel because when you go to the police station, you're already finding a police officer who's on duty. You report your case. You bring a complaint. For instance, a phone that is stolen. And in that process, then the police will ask you, do you still want to continue with the matter, or can you compensate this person whatever loss that has been cut? So the matter has been resolved at that particular stage. So that person did not choose because that person is doing their duty. We did not choose the chiefs because they do their duty, but on a day-to-day basis, they also resolve disputes. We have cases that are resolved through civil society. For instance, you go to FIDA Kenya that handle mostly women and children matters. We do not choose because when you go there, at least we already have trained people who handle, who are able to bring parties together to deal with the matter. So I've been able to handle the different aspects. We do not choose. Where we have to, it depends on the expertise that is needed and the direction we need in order for us to be able to have this engagement. On the issue of inclusion, we've had challenges of inclusion in the past, and the duty of the court to transform is one of the duties that the committee has been undertaking in terms of engagement with the ages practitioners across the country. Where you have challenges of involvement of women, involvement of the youth, we've been encouraging that as panels are being formed, we must have representation because we need to adhere to the constitutional principles under Article 10 of national values that encourages participation of all, Article 27, and the rights of minorities and marginalized communities to be addressed. And so in this regard, we've had where we have mixed communities in counties, where we have mixed communities, involvement of panelists from all the communities, whether they are the minorities or the majorities. Where we've had challenges of women, for instance, in the northern part. Now when you go, you see there's a transformation because that's one of the duties that we have to transform. We've had now women being involved and the young people also walking this journey so that they don't feel, we don't still say that system is for the old people. The system is for all of us. Even whatever is happening in the country in terms of the Gen Z, it's a way of saying, let's have a dialogue, let's involve the young people so that they can learn how to resolve disputes. I think I've been able to address the question, moderator. Thank you.
Thank you very much. And I am minded that Daktari reminds me that elders is not the traditional meaning of an elder, but it is an elder in AJS is somebody who has that agency and who has been capacitated and can be able to sit in a panel and be able to administer justice. Thank you very much, Jemimah, for that. And for the ladies in the house, you will be interested to know that the journey of transformation is real. I give an example of Samburu. Samburu currently has the chair of the Council of Elders as a woman. Previously, the women, even when they had dispute, could not even come close to where the kikao for the dispute resolution was. So there is a lot of transformation going forward, and there is a lot of progress in terms of inclusivity in light of the constitutional principles. As we draw close to an end, I want to come to you, Judge. And as you talk about the do's and don'ts in AJS, I know Article 159.3 places this responsibility of checking the procedural aspects to the judiciary. I want you to talk about that and tie in with this pending question of Okina James. I don't want to leave it hanging. And James was asking to tag on the doctrine of interaction. You had discussed about it. The notion of good and bad varies from traditional perspectives vis-a-vis the judicial modern, and how do we balance these variants? Karibu sana, Judge.
Yes, thank you very much, moderator. So you want me to talk about 159.3 of the Constitution, which has been elaborated upon by Dr. Akoth.
Yes, just touch on it.
Yes, it sets out the outer constitutional limits, which must be met by AJS, both the process as well as the outcome. And it talks of the AJS resolution or process should not contravene the Bill of Rights. And that is what we normally champion. What JEMIMAH has said, we normally tell them in our training that if you do AJS which contravenes the Bill of Rights, you are risking it being struck down by the court. And then we pose a challenge to them, whether they will be willing to engage in a futile exercise. And then because they are reasonable people, they now start appreciating, because we are standing on the Constitution. And it's a matter of relaying information to them rather than beating them into what we think is good. So we follow the script of the Constitution. So anything that violates the Bill of Rights, then under the what I talked about, the review on procedural propriety and constitutional proportionality, it will be struck down. But we normally encourage them to do as much as possible to ensure it adheres to those requirements. Then there is the other one of repugnant to justice and morality. That was explained by Dr. And I don't want to repeat it because it has a serious colonial connotation. But in our view, and Dr. explained the content of what is repugnant to morality and justice, draws upon the provision of the Constitution, and he gave Article 10 as an example of national values and principles of governance. So that has been tackled, and that is what it means. So do not ferry your mind back to what we were taught about repugnance clauses. So it was retained, but in that context, and that's how we interpret it. And then the other one is if it violates the Constitution as a whole or written law. So if the resolution or the process violates the Constitution or the law of this land, then it would be struck down. And that has been explained by JEMIMAH in the context of what we train and what we do in for purposes of bringing in inclusivity, equity, and equality within those processes. So that is a brief explanation of that particular article. It is not the only one, but it is the foundation of everything. But the entire Constitution contains other provisions which you must read, and I think that's why it is cast in a broad style. They say if it is in violation of the Constitution, so bring into play all the provisions of the Constitution. So that is the test. So and that test is quite objective, and I know it has worked miracles for us. And you have even told us in Samburu, the chair of the Council of Elders is a woman. Those are the fruits and the wonders of that particular article. So that is what we use in our doctrines of interaction. And once we restrict ourselves to that, then we get it right as a judiciary, and we are able to promote AJS. So having said that, there is that question of good and bad. The way I understood it is that it varies between traditions and what we think in court. I think if it is within that context, it is a question which is quite broad and not capable of any specific answer. But maybe I would say that the test, drawing from what we have talked about repugnancy clauses of morality and justice, drawing from that, I think the court and also AJS should be able to adapt that test. And I do not think there is any separate test which has been set out by the Constitution for AJS and another one for the court. The test is the same. And if you're able now to place the facts and you look at what the law says and the circumstances of the case, then you must be able to see what is good and what is bad for justice within that context. So I think I cannot give that general answer to that very broad question. Thank you.
Very well, Judge. Very well answered. I want to stick with you.
But let me say something else which we may have forgotten to speak about, if you allow me. 1 minute.
Yes.
This question of enforcement versus obedience of AJS resolution. Many people ask, now once you have an AJS resolution, what do you do with it? Let me say this. Some of those AJS resolutions just call for voluntary obedience, and they don't have to be filed in court for them to have legal force. I said they are complete and enforceable in themselves. So there is that aspect of obedience because of the way they are constituted. That is the emphasis. However, you may be required to file it in court for purposes of enforcement. Maybe because the law requires that, or the kind of dispute you had is such that you need a court order for you to enforce it. If you want to go and change now title based on the resolution by AJS, the registrar will not accept AJS just like that. They will tell you, go to court, have it adapted, bring an order of the court to rectify title. So where the law requires, all the parties, because of the nature of the dispute, must come to court. It is the only time when you require AJS resolution to be filed in court. Otherwise, emphasis is on obedience, and some of them are self-executing. Thank you.
Indeed, thank you very much. The key word here is self-executing resolutions, and you'll find that the parties are amenable to them and they will be happy to implement them. Judge, allow me to stay with you because there's one question here that is directed to you. And Priscilla Ngigi asks, sometimes back, a petition filed in the High Court for removal of a governor from office was referred to AJS. The question is, are there jurisdictional issue in a minute or two?
Yes, we know the specific petition. So jurisdictional issues would arise, but let me give a general answer that there are those mechanisms which have been set out in the Constitution or statutes through which disputes are to be resolved. Take, for example, non-governmental, intergovernmental problems. If they have disputes, there is a way they are told by the Constitution and an act of parliament how to deal with it. So if it falls that, you know, those are not, they say that is AJS, but we would like to set them apart because those are statutory based and they operate within the regulations and rules which have been set by the Constitution or the statute setting them up. So if it is a matter which falls there, then a question of jurisdiction would arise. But if it is not, then it would fall now back to the jurisdiction regulating principle which I talked about. But I think that's a debate which is still ongoing. But I think the less I talk about it, the better. Thank you, Njoroge.
Thank you. Thank you very much.
Can I also add something, Njoroge, on that? Let me add something. Yeah. So remember, we still have Article 159(2)(c) that the judiciary has been given the power and mandated by the people of Kenya to promote alternative justice victims. And so by the court referring the mayor of with Article 159(2)(c) and being alive to Article 159(2)(c), that you can be able to ask parties to go and just the same way we ask parties, please try mediation, try an out-of-court settlement. However, we still go back to the agency. Parties still can come back and say, yes, you had referred us to try these other doors, but we are back to you because we were not able to get a solution or we could not agree. So the agency bit still comes in. So those of us who are advocates here appreciate that sometimes matters are referred to mediation. You go, you have all the sessions. Even for me, I have a matter we've done for 3 months. But we'll be back to court and tell the court, however, even though you had referred us to this, we were not able to conclusively deal with the matter, and we are back to you. So still remember, the people of Kenya have told the judiciary they are supposed to decide matters, resolve disputes through court. But still it tells the judiciary you can promote other mechanisms. However, when it doesn't work, it's an alternative. That's why it's called alternative. You have a choice. You have a choice to say, I'm ready to go for it, or I'm not ready to go for it, I'm back to the court. But with the court, you have no choice. And so parties can still go back to court. And in this case, the parties felt like, no, you've told us to go for AJS outside, but we're still coming back to you. And the court still has to apply the constitutional principles and Article 159 and say, yes, you get them the opportunity as an alternative. They've said no, and they're back to you. Proceed with the matter. Thank you.
Thank you, Jemimah. And by that, I think you have answered some of the questions that are on the chat. Ladies and gentlemen, as we come to a close, I want to bring back Daktari as you give your final remarks. Being a scholar, what is the role of academia in terms of AJS? Do they have a place? Where is it, as you also give your final remarks?
Thank you very much, Chair, and I must say this has been a very good session. So let me start with the role of academia, then I give my final remarks. So look, the first thing that we must remember is that the judicial system and the justice system at large looks tidy, but it is not natural. It is a construct of particular histories, particular context, particular circumstances. When we were at Bomas, we really asked to get a constitution that reflected our lived realities and was anchored in our history. And so the model that we have now, the plural legal system we have now, is not the same as colonial plural legal system. So the role of academia is first to make sure that we expound on that discourse through writing, through teaching, through research, and indeed also through community service, so that then we are aware of the elasticity of what we've given ourselves. The second role of academia is that we teach, and we teach young minds. So those of you who teach in the law school, those of you who teach social sciences, we really must help our young minds to exercise what I call intellectual gymnastics of decoding the knowledge as it appears in our times, the framing. So when you talk about social foundations of law, we don't want our students learning about King Henry. We want our students learning about the implications of inequality to the judicial system, the implications of patronage to access to justice, and so on. So that's really the final role of academia is, as also Jemimah has pointed out, the conferences we hold consistently are all held in the university. Why? The university is a place that affirms. It has got instrument of distilling between opinion and knowledge. So we'd like the academia to affirm that what the people are doing, when it is consistent with the Constitution, affirm that it is right. This is very important, that this is right. This is really it. This is what we mean by decolonizing justice, decolonizing law. Last comment from myself really is to say that the practice of AJS does not start with the arrival of our committee. So even in counties where we haven't established county action plans, it doesn't mean that people are in the waiting room waiting for us to arrive to unveil AJS. No, we only come to affirm and to create a model that can make it visible and workable. But AJS supersedes our arrival. It supersedes the crafting of the Constitution, because the Constitution just affirms it. And finally, AJS is not infallible. The courts are not infallible. The executive is not infallible. However, the issue here is, what do you do with a system that is fallible? Do you discard it and say, this one is not consistent with our system, throw it away? We are saying no. Engage it. That is the real difference between what we are asking for and what was the case before. Engage it. Engage it. When we engage it, we'll redeem ourselves from the mistakes of Eugene Contran. Because Eugene Contran, and Chair, that's where I want to stop. Eugene Contran, when he was living, he said, these natives have been practicing customary law. And in the colonial regime, customary law was fairly flexible. But we don't trust them to think and make determinations consistently. So as we go, we'll write it down for them so that they can make reference. And that's how they killed customary law. They skeletonized it. Let us not skeletonize AJS. Let us engage it and let us give it life. Thank you very much for inviting me. It's such a pleasure.
Thank you indeed, Daktari, for your very exhilarating comments and expose of the AJS and also the role of the academia, demystifying opinion and knowledge. And I can say for sure that I have had a little bird say that the conference may be coming to Embu, the University of Embu next year. So it is the home of demystifying opinion and knowledge. Karibuni sana. Jemimah, as I come to you, as you give your final remarks, there has been questions to do with challenges. Are there any challenges in terms of the implementation of AJS? Somebody has talked about, are we susceptible to issues corruption? So just talk about challenges briefly and give your final remarks. Karibu sana.
Okay. Thank you. Thank you so much. I'll start from where Daktari ended in terms of people waiting or people thinking they're in a waiting launch. So the first challenge is that anxiety that because you've not launched the county action plans, then it means that you're still waiting. No, we are encouraging them to continue even as we come to launch the county action plan. Remember, we are supposed to launch all the 47 county action plans and even model them in such a way that at least they are there to the justice issues of that particular county or the areas. For instance, in Nairobi, we have different, it's so dynamic that you cannot develop one county action plan that covers everything within Nairobi. And so that's one of the challenge, and that comes to the issue of personnel and resources. That anxiety, the judiciary is under performance management that they need to implement alternative justice system. We need to implement STARG. The resources are not adequate. We are really relying on partners, stakeholders, and donors. We all know what is happening in the donor, in the development, legal, in the aid world. Including the issue of USAID. And so the resources are not adequate to be able to operationalize the policy across the country, and trying to have discussions with the communities to continue engaging even as we come. The demand is very high. Number two is the issue of inclusion. We still have challenges of inclusion of other people within the community not adhering to Article 27 of the Constitution. In this regard, I'm not talking just about the women and the youth, but I'm also talking about counties whereby Embu, you coming from Embu, appreciate that Embu has several ethnic communities, but now when you come there, people feel like this is our county, we are called Embu, we are the Embians, and we do not allow anybody to sit in this panel. So we still have that challenge of inclusion. So trying to transform the mechanisms and trying to transform the mindset is still not very scheduled to the people. We still have people who are court-centric, including lawyers, who are concentric, who believe that when you go to court, then matters must be resolved by court. And when the court tells you, why don't you discuss with your client outside, even the clients themselves see, I have to take you to court, and matters must be resolved by court. So people still have that challenge of appreciating that when you have even discussion outside court, you still get a judgment, because whatever you agree, then you come to court, the court will be able to adopt and give you directions. So that has still be a challenge. Of course, we still have the challenge of integrity. Whereas we are encouraging AJs to be organic and people to continue resolving disputes, some feel like it's an opportunity for them to make money. It's an opportunity for them to give awards that are favorable to their parties and all the other parties, like the case that judge has given an example in Narok. That becomes a challenge because now people still have that mindset that these people are corrupt and we cannot go to AJs. Lastly, we still have that mindset that AJs is about the traditional. We still think about elders being the wazes. We still think of AJS as being a kangaroo court, and people still saying, I don't understand what is happening there. Yet AJS is practiced in our estates. When you have issues within the estate, we call our leadership. AJS is practiced within our chamas. When you have issues within the chama, we're able to resolve. That is an AJS. AJS is still practiced within the chief's places where we have dispute. People go to the chief's camp, chief barazas, and they're able to resolve. AJS is practiced within the civil society organizations, even in the court. So we still have that. And lastly, of course, different institutions understanding AJS in different ways and feeling like, oh, this is not a policy I need to implement. I only want to implement my own policy. So you feel like diversion. People think diversion is separate from AJS, but it's an AJS. Plea bargaining, it's still an AJS. It's still one of the children, as Dr. said, of Article 159 2C. Back to you, Chair. Thank you.
Thank you very much, Jemimah, for that sum up. Indeed, one of the challenges is about my learned friends, whether it is we are cutting off the bread and butter, but what I want to submit to you is that bread, when you look at the statistics, disputes that go to court are 21%, 79 are resolved out here. Do you want to stay in the 21? Do you want to join us in the 79? I submit to you that the bread is even bigger. The bread will have more butter, more peanut butter, and jam. So, karibuni sana. Thank you for that. Judge, I want to finally come to you. And just a reflection, what is the future of AJS and the judiciary in the country? And you do your final closing remarks. Karibu sana.
Oh, thank you very much. As one of the members of the steering committee, I would say that AJS really offers unlimited opportunities to the people of Kenya to realize their full potential and protection of rights. It has a bright future. I anticipate real-time and acceptable resolutions from AJS, which will motivate people to even continue going to AJS and transform them. But I have a question. That it is good if we leave AJS to emerge organically, rather than restrict it or try to channel it through legislation and strict rules. That is important. As I still reflect on the future of AJS, there are still challenges and dilemmas, and I think the judiciary should continue to work on them, remove or severely mitigate those challenges and dilemmas, especially on the front of human rights and the right to be heard. I still say it has a bright future. And borrowing from what Dr. Akoth has submitted, I can see a large body of knowledge and source of jurisprudence as a result or outcome of engagement or deployment of AJS. I also see, when I look ahead, Kenya becoming a center for regional and international reference and sharing of experiences. And sharing of experiences on AJS. And I can tell this or attest to this from meetings which we had in Uganda on a regional forum on AJS. And you can see a lot of benchmarking was coming from Kenya. So if we get it well, I can assure you we can make Kenya a center for regional and international reference and sharing of experience. So we need a responsive judiciary. We are working on that. And I always tell my colleagues that the judges should deliberately set out to promote AJS. And when a question of AJS arises, and you have seen an example from the Court of Appeal, it is taken with seriousness and a difference that it deserves. So AJS is the future. AJS, we always say it will change the narrative conversation in Kenya. Thank you very much for listening to me.
Hi, thank you very much, Judge, for that informative session that you have had. I hear you say that you shall not muzzle, you shall not gag, you shall not interfere with AJS, and that is none other than the judiciary speaking. Ladies and gentlemen, the future is AJS in terms of people-centric justice. It is organic, it is natural. Let us nurture it, and of course, with the guidance and the human rights approach. I want to check just one through the charts to see whether there is anything that is left unanswered, as I also prepare the chair or the CEO to prepare in 2 minutes to come and do the final remarks. Ladies and gentlemen, we tried to infuse the panel questions and interactive nature together with the questions, and I think I have largely tried to do that. So if there is any unanswered question that is on the forum, we'll pick it up. And due to time, we've overshot by 25 minutes already. We can't be able to get back to you. But I want to thank you very, very much. We've had at a high of 150 of attendance, and it has been great. We hope that as the NACI AJS committee, we have been able to demystify some of the many myths. We have been able to inform. We have been able to sensitize. We have been able to educate the participants about what we submit and the gospel that we preach, that indeed AJS is the way to go, and a people-centered justice is the proper way to administer and resolve our disputes. CEO or Chair, Prof, are you available? I see very good comments and feedback, very good session, well presented. Thank you very much, very informative. Participants are asking for the recording. CEO, you can also comment on that. I think we always do that. Wonderful presentation, very insightful. An amazing session. Thank you very much. Yes, members, very, very positive feedback. This is an area, Kenya, you'll be interested to know, is the first in Africa, in fact, in the world, to go back to our roots and seek to resolve our dispute using our alternative systems, which include the traditional mechanisms. Our chair has been gallivanting the world speaking about this because it is one of are kind. Chair,
Thank you very much.
Karibu sana.
Thank you very much, VC. I have enjoyed this. You really brought the gurus of this subject onto the platform. And the way we are leading the charge here, VC, Daktari, Honorable PJ, JEMIMAH, I think there is a case that can be made for cross-border discussions on this issue. Of course, this is the continent of Africa. Many say the cradle of humankind in every respect. I don't know, VC, whether that is a conversation that is being had in the AJS circles, how you could, more or less in the nature that the South Africans brought Ubuntu, and found that as a principle running across, whether the novel work that you've done can draw in other countries, and even in our conference, that to talk about it beyond the 254 jurisdiction. Your thoughts, VC, on that?
Yes, indeed, that is part of the strategy. Just sharing the successes of what the AJS work is doing in Kenya. And I can draw just an example. Last year in the mediation summit, we had a judge from Uganda. They had taken this from us. They have implemented it in Uganda, and it is taking a very good ground. They are actually more, unlike us, who are more targeted to civil and succession. They are going the criminal way, and it is helping them a lot. Malawi, Mozambique, South Africa, and other countries have also come on board. And I think, as you are suggesting, the ADR will be a very good place to bring all these players together so that we can have a baraza and chat on the way forward for Africa to have a people-centered justice. Thank you, Chair.
Okay, thank you. Maybe sorry for intervening. Sorry for the intervention, but just to let us know that this year, as the NACIAGES, we've had 5 engagements with different countries who have come to do benchmarking in Kenya. That includes Uganda, Ethiopia, Uganda, Somalia, Zanzibar, and South Africa. We've had an online webinar because their engagement. They are trying to also set up, have an AJS policy like ours, and also internationally, where the judge and Daktari have been able also to have this discussion with other players outside the country. Thank you.
Thank you very much, JEMIMAH. That is very, very useful, and it was good when we have done such tremendous work as the task force to be able to radiate it into other areas, and for that richness to be felt. I know, again, I use that example. The South Africans did that in the world of jurisprudence with Ubuntu, which they were able to trace as a common theme in different African societies. So my sincere appreciation to the panel, Honorable Justice Gikonyo, PJ, I'm so happy to see you. I know we have some pending business on the side, and hopefully we should be able to meet, but you have been a champion of this in the judicial system, and we are very, very thankful. Thank you again also to Daktari. Doc, we also have some pending business on the PhD program, very novel that you're running in this area. Very, very enjoyable listening to you and the passion with which you exhibit when we are speaking on this subject. You make very, very technical terms, others very simple terms, accessible to all of us. And asante sana also to JEMIMAH. You bring the conversation home to not just lawyers and practitioners, but to everyone else. So VC, with those comments, we really appreciate the work, and we really look forward to how you will take this forward As the chair of the ADR week, I think there is so much possibilities that you're thinking about. With those few remarks, let me then welcome the CEO to just hone us on many other activities that are happening. The Institute is busy partnering with different sectors and reaching knowledge. CEO, karibu sana. Very, very good to have you with us.
All right, thank you, Chair, and thank you, VC, and to our panelists for such an informative and enlightening session. I mean, we just need to look at the comments to see the impact that this conversation has had. And that's why at the Institute, we keep on having this conversation, because we know the value they hold, and getting the experts in the fields to come and champion this conversation is something that we're really, really proud to support. In the midst of all this, we have had the need to constantly have these events and this conversation, and that draws us to the event that the chairman is talking about, which is the inaugural ADR week. And as the name suggests, we are bringing in all the major stakeholders on all fronts of ADR, including AJS. And we'll have a specific day where we'll be discussing purely issues of AJS and mediation. And the ADR week is going to take place from the 17th to the 21st of November. It will be held at the Kenya School of Government in Lower Kabete. And we'll be having about 500 stakeholders drawn from different areas. We have a specific day on construction, adjudication, and infrastructure disputes. We'll have a specific day on arbitration, as I mentioned, on mediation and AJS. We'll have another day specifically, even the young members group, because we're all about inclusion and diversity. So please mark your dates, look out for the information around that. And you can imagine if this is just a snippet of what it is that we are preparing for you for the ADR week. And in line with that, for those who may have seen in the invitation to this webinar, this forms part of our State of ADR research. And the State of ADR research, State of ADR in Kenya research, is an initiative that we've taken at the Chartered Institute of Arbitrators to be able to curate the data on the different facets of arbitration, of the different facets of ADR. So today we're specifically looking at AJS and TDRMs. And in addition to the content we've been able to generate from this conversation, we have also prepared a number of questionnaires. And I see the team has put a questionnaire on the chat function. We really need your contribution, because this is the information that we need to be able to influence some of the policy that Jemima is talking about, or some of the issues that we'd like to incorporate to ensure easier access to justice for the people who are interacting with these ADR mechanisms, and not even forgetting the people who want to do business in Kenya. They want to see how is it in terms of access to justice, easier mechanisms of dispute resolution. So the State of ADR research aims at capturing this data and putting it in a document or a report. And the content of the research is what we will be discussing during the ADR week. So it is very, very important that we are reaching out to you to participate, because with your information, we'll be able to analyze the data and put it in a package that is easily used by all the stakeholders involved. In addition to this, we will continue hosting these webinars. We have another one coming up on the 7th of August. We have another one coming up on the 12th of August, and another one on the 20th of August. So for the next month, we have about 4 of them. And we are hoping that you're following us on either one of our social media platforms. For those people who are members of the Institute and would also like to be part of our WhatsApp group, you can reach out to us and we'll make sure that we share those credentials with you. We believe information is power. And not only are we going to get this information through the research, but even in such platforms where you can now know what it is that you need to do to be able to gain, first of all, get to network, get to, continuously professional development, and above that, continue honing your skills as a dispute resolver. So thank you so much for that. I just wanted to highlight that very, very specific issue. And for those people who are, you have the stakeholders here, the approach that you're taking currently, and this is championed by our chair here, is collaborate, collaborate, collaborate. If you have a specific topic that you feel is that you need a platform to engage, we are providing that as an institute. Let's constantly have this conversation on arbitration and ADR, AJS mediation, because by doing that, we continue honing the skills, we continue providing the value that our members want, as well as our stakeholders, and we continue promoting dispute resolution and access to justice. So please take your time, look through the questionnaires. We'll also share the same in your emails, should you maybe miss out. Also, for the purposes of this webinar, it has been recorded, and we will be sharing it as well on the CIArb YouTube channel. So you can be able to access it at any time if you want to have a reference to something that was discussed. Thank you so much. Back to you, Vice. Back to you, Vice Chair, for your guidance on anything else you'd like us to talk about. Asante.
Yes, thank you very much, CEO. I am guided by the time. We are at 4:38. Members have been very patient with us. It was meant to end at 4 p.m. I want to thank you all members for staying through and remaining very, very participative through our chat. We hope that we've been able to pick most of your general questions and have responded to them. And as the CEO has said, look out for the recording for those who may have missed part of it. Otherwise, as the CIArb, we continue to do this. We continue to disseminate information for the people. So I send you out the go and exercise your agency. Thank you very much. Have a good evening, and guests may leave at pleasure. Asante.